Hi, my name is Patience Ren, and my colleague Clark Waldon and I are from Holland Law. We are attorneys that specializes in intellectual property law. So as you can see here, we'll be giving a beginner's introduction to intellectual property law. So if you're thinking about a cool idea, but knows very little about intellectual property law, this presentation is made exactly for you. Before we dive into the materials, being lawyers ourselves, we're not going to let you get away without hearing some disclaimers and fine prints. So first, we're providing a very broad intro. So hopefully after today's presentation, you will walk away with some working knowledge, such that you could get a handle on the jargons and some basic framework for you to do either more self-study or to continue that conversation with a legal professional. And nothing provided here is legal advice is specific to any situation you might face. And due to the scope of the presentation, we only cover general or one or more most common scenarios, and it's impossible for us to cover all situations. And if you know anything about law, any rule of law that we present, there are always exceptions. So please do not assume that whatever we say will apply in every single situation. And lastly, just because you're attending this webinar or reading the materials I present, there is no attorney-client privilege. Okay, having that fine print out of the way, and here are the disclaimers in actual fine print, but I'm not gonna make you read that, and what I just said kind of summarized that. So the objectives for today's seminar is we're gonna give you an overview of intellectual property fundamentals, including what is intellectual property. And after that, we'll walk through each of the 4 main categories of ways to protect intellectual property: patent, copyright, trademark, and trade secret. And we'll also weave into how we apply them and how they're important. And lastly, we'll go over the hypothetical scenarios, those scenarios that you just voted in the very first poll. Okay, what is intellectual property? Before I go into give you a formal definition of intellectual property, I want to draw your attention to other properties that you might already know. For example, you probably know about real property, just like a house or a piece of land. You probably also know about personal property, just like your furniture, your bike, your electronic devices. And the reason I want to draw your attention to those is property, even whether it's real property or intellectual property, they share some similar concepts. Even though the jargons are different, I want to highlight to you that what you know about real property or personal property may often apply to intellectual property. For example, there are the things you could do with either real property or personal property. For example, you could sell or buy land, you could lease a car. So those concepts also apply to intellectual property. For example, if you have a piece of intellectual property, you can sell, you can own it, and you can buy them. And just like when you rent a house or you lease a car, you can also license your intellectual property, but instead of getting rent or monthly payment, you get royalties. So these are some of the names, some of the words are very specific to intellectual property, but the basic concept behind them can be very similar. So what is intellectual property? It means creations of the mind. So examples of creations of the mind include branding, how you market and promote your product or your services. For example, your company name, your logo, the colors that you use to illustrate your product or services. Invention, a smart idea that you come up with, a new way to do things, a new product. Content, things that you actually write, whether it was a thriller movie script or source code underlying people's favorite app these days. And lastly, secret formulas. For example, things that are secret, like the Coca-Cola recipe. So these are what we meant when we say intellectual property. And how do the intellectual property play in our economy today? Is very, very significant. So across the United States, IP-intensive industries account for over a third, or more than 38% of our country's GDP. IP accounts for more than half of our exports, which amounts to nearly 842 billion. And the direct and indirect economic impacts of innovation account for more than 40% of US economic growth and employment. And mind you, these numbers are based on 2019 data. And these numbers also apply across the United States. So if you want to just think about California or Silicon Valley, I'm sure the numbers are extraordinarily high. So aside from being important to our economy, why would you want to protect your invention? Well, first, it showcases your technology. Just because you come up with the idea, how do you make sure other people know that you came up with it? So it's important in fundraising situations. So there's economic benefit to making sure that that invention is attributed to you. There's also reputational recognition, which is the people in academia may be more familiar with. They're the moral rights. People should recognize that you are the inventor or the creator of that intellectual property. You can also minimize competition in your field. If you have a right granted to you and you assert that right, you can protect an area of research while you work on a prototype. You do get licensing revenues. And after all, it incentivizes you, your employers, your partners, people on your team to innovate and to stimulate economic growth. So now I want to move on to the specific type of the four main types of legal framework our country, United States, offer to people who create or invent. So the first type is patents. It protects inventions, as I've said. One example is the best mousetrap ever. The second type is copyrights, and it protects expressions of ideas rather than ideas itself. It could be your novel, or again, the code that you write for a particular app. The third is trademarks. It identifies the source of that product and services, like AirPods. When you hear or read that word AirPod, you know it implies so many things. It implies you know what the product is, you know where the product comes from, it's Apple, you know what it does, and it implies a certain look, quality, and function that you associate with that source. And then lastly, there's trade secrets, secret information with commercial value. So one of the most well-known one is the Coca-Cola recipe. So now I want to delve deeper into the patent category. So what does patent protect? There are three types of patents that United States offer to its inventors. One is utility. It protects new and useful processes, machines, article of manufacturers, composition, and matter. These are a lot of legal jargons, but basically it's methods and things that are new and novel and not obvious. The second category is design, new and original ornamental design. So it could be how your electronic device look, how your earphones look. It's not functional, but it's ornamental. And then lastly, for the sake of completion, I want to let you know that there's also a plant category, even though I'm not sure how many of the IEEE members will create a new variety of plant, but that's definitely a category of plant that United States offer. And who are the people implicated here? So the creator, who we call the inventor. And we also want to keep in mind that the owner of the patent is not always the inventor. Usually invest in the inventor first, but a lot of times there's separate agreements that make changes to that assumption. And what does the patent grant you? It grants you the right to exclude others from making, using the invention, offering for sale, or actually selling or importing it. So remember, this is a right to exclude others. It does not give you a right to practice, because if you get deep into what the patent grant is, so many patents are filed every single day. Many inventions could be overlapping, and sometimes it is unclear. I'll talk a little bit more about that in the next slide. But regardless, it is a very strong monopoly. It gives you an absolute right to exclude every single entity from doing what you claim you have invented. And how long does it last? The grant of right is 20 years from the filing of your application, or 15 years from issuance if your creation is a design patent. Now, these numbers, as I've said, is generally right, but there are always exceptions, and the exceptions are numerous. So, and to delve into the length of the life of a patent is actually could get very nuanced and complicated, but that's generally the time frame. So if you ever come across a patent that you're very interested in finding out how long it lasts, I will recommend that you have to do more self-study or consult a legal professional before you're absolutely certain how long that right lasts. And what does the government get out of this patent system for giving you that monopoly? Well, on your end is a quid pro quo system. On your end, you're obligated to disclose the invention to a certain standard in exchange for that exclusive rights. So you have to divulge as much details as you need in that patent, and when it's published as an application, it becomes publicly available to everybody in the world. So that is your responsibility for receiving that almost monopoly rights. Just to talk about patent in a more in a context that some of you might be familiar with. These are the two notable cases that I can think of where patents play a very important role. So some of you might have remembered there's the Apple v. Samsung litigation. This is not just one case in Silicon Valley, but multiple cases around the world, both in Europe, in Korea, and it's not just one patent, it's multiple patents that Apple asserted against Samsung. Industry insiders will tell you this is essentially a battle between OS phones and Android phones. So some of the interest when Apple asserted multiple patents against Samsung, Samsung also counterclaim with their own patents in that litigation. But it is Apple's patents that's the star of this litigation. And some of the patents include design patents and utility patents. Some of the design patents that you might be familiar with in that litigation is rectangle with rounded corners. And other utility patents are implicated is a method of doing things for the user, or in other words, the graphic user interface, slide to unlock, or swiping motion, zoom in and zoom out. So all of that is implicated. Those are utility patents that were implicated in that lawsuit. Another lawsuit that some of you might have heard of is Rambus versus NVIDIA. It was a pretty big case, started around 2010. There were 17 patents. Eventually, some of the patents were found invalid. Some of the patents were found infringed. The case ended when the parties reached a licensing deal. So just a pause from the presentation in case anybody have questions or want to interrupt me with questions, feel free to put it in the chat or question and answer, and Joseph and others will see when is a good time to interject. I'm happy to be interrupted. I would love this to be more interactive, but this is a Zoom webinar, so we're a little bit limited that way, but I just want to put it out there as an option in case anybody has a specific question. Okay, now I want to kind of give you an overview of anatomy of a patent. A lot of you might have seen a patent document, but do your eyes just glaze over? What kind of information can you glean from it? So I just want to give you a basics of how to read a patent document, what they mean. So as you can see at the top left-hand corner, it says United States patent. And I just want to take this moment to emphasize that a lot of intellectual property rights, including patent, is given on a country-to-country basis. For the European patents, a little different. It applies to all countries that have participated in that European Union. So we call it EP, European patent. But in most cases, it's country by country. Just because you get a United States patent doesn't mean that your products and services marketed or sold in other countries will not get the type of will receive the type of monopoly rights that you get in the United States. Okay, and on the right-hand corner, you see that there's a patent number and a date of the patent. The patent number is a way to identify patents that have been issued, and the date of the patent is when it was issued. And underneath that, you will see there's the title of the patent and the inventors. Inventors are important because it tells you not just who the inventors are and where their city of residence is, but oftentimes many inventors file multiple patents. So if you come across a patent that's of interest to you in a specific field and invention, sometimes you can search for other patents and publications by the name of that inventor. Sometimes you will find a whole family of patents related to that specific invention. And that's a good idea to get an overview of the patents in that field and the invention. And underneath the inventor, you will see a line for assignee. Assignee means the entity or the person who actually owned the patent. As I said, not all inventors own their patent. As a matter of fact, many inventors who work on their invention as an employee of a company are obligated to assign over their ownership of the patent to the company. So assignee is also an important information because if you search for other patents under that, using that assignee name, you can actually get a quick window. There's a quick window into what the company is working on. The latest patent will give you an idea of what the company find worth patenting. And underneath that, you see the application number, the date of the file. That will be important to calculate the expiration date. And underneath that, there's other information that will be of interest, but it's not presented in this particular patent, but oftentimes in other patents, you will also give you information of related patents. Patents are parent that file before it and file after it, which we call parent and child. So those are the family of patents revolve around a similar idea, different variation of invention. Again, additional information if you want to get a good lay of the land. So next I want to move on. The anatomy of the patent separate from this cover page, which is specification, drawings, and claims. Specification sometimes also includes drawings depending on the vernacular, but basically it's the prose, is the paragraphs, everything that is in the patent to describe the invention in prose. Now, let's see. So this is the same patent, but I'm showing you one of the drawings. And on the right-hand side, I'm showing an excerpt of the claims. I want to spend a little bit time talking about claims because claims is what defines the scope of your invention and what your invention actually is. You might think, when I read a claim language, it just seems so vague, unclear, And why don't people just talk like normal human beings instead of talk like patent attorneys? Now, there's a reason why the claims are so verbose. So as you can see here, this is a patent on a shoe and a mechanics of the shoe that allow the person who wearing the shoes to be attached to the ground. And the claim says a system for engaging shoes with a hitch means, so there's a typo in that claim, which is actually not uncommon, to permit a person standing on the stage surface to lean forwardly beyond his or her center of gravity, comprising, and then there's a colon, at least one shoe having a heel with a first engagement means set first engagement means comprising. As you can see here, there's so many components here and so many words here. And when you first read it, it might seem confusing. But if you get used to reading it, it actually provides a lot of details. So I want to give you an example. So for example, if you want to convey to a normal human being what I'm holding here, you will say it's a pen. But if you want to convey it to somebody in the patent field, patent attorneys, patent examiners, potential investors who want to understand what your patent covers, it's the claims. You want to describe it as not just a pen, because that's actually vague in the patent field. You want to describe it as a cylindrical of a particular diameter and length with two ends. Set first end is, and then you'll describe this end, and then you describe set second end is a conical shape ended with a graphite tip. Actually, some patent attorneys will even say that is not specific enough. But I'm just giving you an example of how common vernacular does not always translate to patent claim language. And that's why do not be intimidated by reading patent language. After a while, you'll understand why it needs to be as specific as it is. So to obtain a patent, you have to apply, you have to file an application. The application is examined by the patent office. And if the patent examiner finds your patent to be to clear various hurdles, then you get a grant of a patent. And that process is actually not trivial, but it's beyond the scope of this webinar. I'm just going to give you some broad scope as to what invention or what hurdles you need to meet to get a patent granted to you. One is utility. It has to be useful and apply in real life. It cannot be an algorithm, mathematical algorithm, law of nature, or a mental step. So if you think about a brilliant idea that requires a person or a machine to compare two numbers and pick a larger number, for example, first, a human that does that is a mental step. That's not, if your invention is just that and nothing else, that's not patentable. If you have a machine that does that, well, it by itself is probably also not patentable, but unless your machine does it in such a novel, non-obvious way. The second hurdle, well, I'm combining the second and third hurdle. It has to be novel, meaning new, and non-obvious. And that means that compared to everything that came before your filing date, it has to be different and not obvious. And when I refer to what came before the filing date, people often refer to as prior art. And that includes not just peer review references, it could review actual products that are sold anywhere in the world, PhD thesis in a library that nobody checks out, as long as it's publicly available in any languages in over the world, that could be considered prior art. Of course, some people say that, do I have to be so thorough and exhaustive in investigating prior art before I file a patent application? No, you have some duty to understand your field, but it's impossible to be exhaustive. But I just want to make you aware that if anybody wants to challenge the validity of a patent, that's what people do. People look at every single prior art that's available before your filing date. The next requirement is adequate written description. So that means that in the specification, which is the part of the patent that's prose or drawings, you have to adequately describe your invention to show that you actually have it. For example, you can't say, time machine, and then you claim time machine. I claim my invention time machine because you have not adequately described how it works, how it's applied, then you will fail the adequate written description. Similarly, the last requirement is enablement. When somebody in your field reads your patent, you should allow them to reproduce or to make or use your invention. It's very similar to the time machine. Sometimes adequate written description, adequate enablement kind of melts together in terms of how you can meet those two hurdles. Some of the patent filing strategies, there's two types of patent you can file. One is called provisional patent application. That applies to utility and plant patents. Design patents don't have the option of filing provisional patent. Or the non-provisional patent application. So the patent application that we see that's eventually granted, we call it non-provisional or just regular patent applications. But there's one trick that you could do if you're not ready to file a non-provisional patent application. Before that, you could file provisional, and the purpose is to hold your place in that queue. Because in the United States, there are sometimes time constraints and how urgent you need to file your patent application because of the prior art issue, because you are eventually going to publish it in a paper or publish it in a conference. So you want to make sure that I have a placeholder in my queue to demonstrate that I'm first to file, that I am first in queue. So that's the purpose of the provisional patent application. And it holds your place in queue for 1 year. It's not examined by the patent office, and you're optional. You don't have to put claims in it. Now, after that one, or within that 1 year, you have to decide whether you should file a non-provisional patent application, because that's what eventually gets you the patent. The provisional one, the 1 year one, does not grant you any right. It only holds your place in queue. So in that non-provisional patent application is examined by the patent office, and you're required to have claims. Claims are kind of like the boundary of your house or your land. Without the claims, people don't know what your invention and what the scope of that invention is. So just to go a little bit beyond the United States jurisdiction, a common strategy is for people to file the provisional first. A lot of times is inventors going to publish in a conference and they talk to a patent attorney and everybody rushed to file provisional application before that conference. Provisional application, as I said, takes a little bit less time. It's a little bit cheaper because it's very basic. Claims are optional. Some inventors even just put their draft of a peer review paper in that provisional. But you want to be careful that whatever non-provisional you eventually file and whatever claims you eventually want to put in there, you could derive that from your provisional to preserve that date, that 1 year before date. Because if you just make up a claim that's completely unrelated or hard to derive from your provisional, the patent office and your competitor may not honor that early place in queue. So you file provisional within 1 year. You can decide to file a non-provisional in the United States, or you can decide to file an international application, and that kind of triggers your ability to file patent applications in multiple countries. Because that is very useful for people who want to capture markets beyond the United States. And when you file that international application, within 18 months, you can make a decision whether in which country you want to file. And a lot of countries participate in that process, but not all. It's called PCT. PCT is the treaty that the countries sign on to say, yes, you can keep that. You can file one application as an international application, PCT application, and then later on within 18 months decides when you want to file in each country.
So Patience, we have a few questions.
Yes.
If you want to take a look.
Is there anyone that you could let me know? I don't know
Sure.
if I can see the chat. Yeah.
Um,
I can read them
compare,
out.
no,
You want me to read them out?
sure, go ahead, Selwyn.
All right. So the first question is from Tom from Airware. Compare whether to have the filing public or non-public.
Yeah, so provisional application is not public, and it will never be made public unless you convert it to a non-provisional. So if you file a provisional application and then later decide like that's not, somehow it does not work out, you can never file non-provisional and that thing will never be public. However, when you file a non-provisional, I believe it's about, I forgot what the time frame is. It could be 12 months or 18 months after your filing date, it automatically becomes public. It's a public disclosure. And remember, not all non-provisionals get issued. You have to clear those hurdles by the patent office. So even if you do not clear those hurdles, once you file a non-provisional, it will become public. So that's something that you definitely have to keep in mind if disclosure is a big issue for you.
Thank you. Okay, we have a question from Aditya Naresh. Would you be briefly covering the role of patent trolls as well as in the overall patent economy and how it can impact individual inventors?
I think my colleague Clark will cover that in one of his hypothetical scenarios. A patent troll is a big, it definitely has a negative impact on our economy. It also, but making policies that exclude patent trolls, but somehow preserve innovations for small entities and academic institutions can also be tricky. And that's a very much a big policy question. I'll let Clark take care of it and see if we have time to discuss that, but yeah.
We have a follow-up question from Aditya. I heard from my company's policy to not research prior art patents because it can impact the novel requirements, particularly when it comes to IP lawsuits. Is this true? If so, could you briefly describe what that means?
First of all, I think you have to comply with whatever employment agreement you have with your employer. And again, there is ethical obligations by both the patent attorney and the inventor who file the patents to disclose everything that is relevant to the examination of the patent. And that ethical obligations have to be upheld. If you don't comply with the ethical obligations, there is room to invalidate your patent. The question is, how far do you have to go to make sure you're compliant? Well, first of all, do what your company says. Second of all, as I said, there's no obligation for you to be exhaustive, but just as a person, ordinary skill in that field, without doing extra work, you still have to disclose what you already know that is relevant to your patent applications. But again, definitely consult your company counsel on that issue.
Yeah, I'd like to add a point on that. So like Patient said, definitely consult your company counsel. But from my understanding of what happened in my past companies is that typically they ask you not to research prior art for you to submit your idea to your company's legal team. And once that's submitted and the legal team does that analysis typically about the prior art and like everything else. So that's how it's been in my past life as well. All right, one last question. Can you please explain how one can access and search the USPTO patent database?
Yeah, I will share some links at the end of the presentation, but generally, if you search for USPTO, which is United States Patent and Trademark Office, it will give you a lot of resources and give you links as to how to search for patents. This is United States patents. You can also definitely use patents.google.com. If you type a US in front of a patent number, it gives you only US patents. It also gives you worldwide patents in any jurisdiction. So patents.google is a very good resource too. But I'll definitely reshare those resources at the end of the presentation.
All right, thank you, Patience.
Thank you. Okay, some of the bars to patentability I want to make sure inventors and entrepreneurs are aware of. So something that could prevent you from getting your patent right, I'm listing some examples here. If there's a printed publication describing your invention, you got to wrestle with that. It will be a big hurdle. Or if there's a public use of the invention, so before you file public, your patent application, some use has been already done publicly. An offer for sale, even a secret sale to a secret partner. Supreme Court recently found that that could be a bar to patentability. Or another inventor who's not related to your team, not related to your institution, filed the patent application on the same invention. Now, there's some exceptions to the printed publications and the public use. If that activity is less than a year old, involved the same subject matter, and was also derived from yourself or assigned to the same entity. So to put it in context, if you're thinking of making a sale a sale of product or service that embodies your groundbreaking invention to somebody, that should trigger something in your head. When would I do that? Do I have a patent on file? If not, can I file it within a year period? So those are the things that you should think about when you start doing some when you start thinking about commercial activities to your patent application. Okay, that we're done with copyright. We're done with patent. The copyright is short. It covers original works independently created by a human. There's also discussions about what happened to work created by machines. I think that issue I'm not particularly familiar with because there's quite a flux in policies. And you may think copyright protects like very, very creative ideas and stories, and no, it just requires some modicum of creativity. It cannot protect short phrases or words or very familiar symbols, but any expression of idea, it can be protected. Usually we call people who create those content author or owner. Again, author is not always synonymous with owner. Once you have the copyright, you have the rights to reproduce, perform, display, distribute copies, prepare derivatives. The length of the copyright, again, generally is author's life plus 70 years. And here are some of the notable cases where copyrights are implicated. Again, the litigation that we thought will never end, Google versus Oracle, I think if it recently ended. If you're familiar with that case, what's implicated in that case was Java API. Oracle bought Sun Microsystem, and they have the copyrights to that. Again, copyright can get really complicated when you talk about what is copyrightable and the defenses, and that's definitely what that litigation is about, whether the API, the Java API is copyrightable, how much was supposedly copied by Google. And that's kind of beyond the scope of the webinar. But if you're interested, there are many blog posts and things on the internet that you can read about in that case. And similarly, Arista Networks versus Cisco, Ethernet switches, command lines. Cisco claimed that those command lines are copyrighted, and Arista Networks use those command lines. And one of the earlier cases, Apple v. Microsoft. In that case, Apple claims that it originally owned the idea or the expression of the idea of using Windows to represent, different programs. You can have your computer, and Microsoft stole that. So those are some of the cases I think in popular media that you might have heard of that involve copyright. My So copyrights is a little different from patents. You don't have to register, even though registration is highly recommended. Even if you don't register, just the fact that you create something lets you own that copyright. Registration gives you a little bit more, gives you more protection, and it's a very straightforward process with the US Copyright Office. So that's something to look into. I think, okay. Well, sorry, I'm taking more time than I thought. So I think I'll turn this over to my colleague, Clark Waldon, to finish the presentation.
Before that, we have one last question, if you can answer that. Can you comment on what the SCOTUS decision on Google versus Oracle means going forward for open source development, for example?
It's actually a very complicated question. There's argument on both sides. Some people felt that it really destroys the ability for people to own what they have created in various languages and open source software. What it means to be open source. To be honest, I'm not completely familiar with the nuance and all the multiple decisions that came with that litigation, but generally, a lot of people believe that it's good for competition. The fact that Android lives on and doesn't have to pay a huge fee to Oracle. But to be honest, a lot of scholars are still wrestling with that decision. So yeah, let's wait to see how it shakes out. I mean, I don't know if Clark has any comments he wants to make, or anybody else.
I think that kind of covers it well, I would say. Yeah, there's a ton of moving parts to that, so it's hard to really give a 100% clear answer on it, but all right. So
Okay,
do I need to?
Clark, would you want to get started with your presentation?
Yeah, I'll get started with mine and then Pigeon. So I just need to switch sharing.
Right. Okay. Sorry.
All right, 1 minute.
While Clark is pulling up the presentation, there was one more comment here in the chat. When Apple wrote their own code and Google did not, it seemed pretty clear that Google could have moved forward without copying the 17,000 lines of Java code. Seems more like a comment than a question. So it's going to be copy.
Yeah, I think there's like, I'll definitely, how about this? I'll refer, these questions are kind of very complicated. And as I said, there's a lot of unsettled facts in the law that come from the Supreme Court decision. And some people do feel like, oh, it's unfair. Some people said it's completely fair. So I can find some good resources for reading materials, for your nighttime reading materials if you're interested in that, because it's definitely beyond the scope of this webinar. I apologize.
All right, can everyone see this all right?
It's not in the presentation mode, but we can see your screen.
Yeah.
Do you want to hit the slideshow up top and then select from current slide?
Let me try. All right, is that better?
See your notes now, PowerPoint notes. Yep. All right, we see the screen share. Yeah.
Do you do this at the bottom right-hand corner? You can also enter the slideshow mode. Display settings. There's a slideshow icon.
Yep, we can see this. We probably just need to move to the.
All right, is it showing just the slides?
No, I see the whole PowerPoint presentation.
All right. All right, well, I can't get it figured out, so I'll just go along with this if that's all right. Yeah, so going into the trademark area here, so trademarks are going to be a word, phrase, slogan, symbol, or design, or a combination of all this. So really, we're just looking at what the branding is, what your brand name is, what your logos look like. Sometimes.
Hey, Mark, we're seeing the first intro slide. We're not seeing the trademark slide. Just probably click through it a bunch of times. Yeah. Perfect.
Okay, awesome. Yeah, and so in addition to getting a logo trademarked, you can also sometimes get color, smell, sound, or shapes, but those would need to be very distinguishable and recognizable. For example, like the MGM lion roar at the beginning of movies is something that's been trademarked. And so the purpose of trademarks is to identify and distinguish a specific product from others in the marketplace. So to make sure people know where the good is coming from, which is your business. Who owns this? Usually a business owner, but whoever is the first to apply for a federal trademark is going to have rights over that trademark. And then you get the right to exclude others from using your trademark once you register it. And then the trademark also lasts for as long as you are using that trademark. So you can't stop using the trademark at any point. You need to continually be using this on goods and services. Here are some classic examples of trademarks that we quickly recognize, whether it's the Nike and the swoosh symbol, Google, Disney, the McDonald's M, Coca-Cola, the Apple logo. These are all trademarks that we recognize and have become famous. So for trademarks in the US, so I've mentioned federal trademark registrations, which is going to give you the most protection. If you have one federal trademark, it covers the entire United States region. Whereas if you decide not to register a trademark, you also have common law rights in the state that you're using your trademark, but that is geographically constrained. So if you're just in California and you don't register your trademark, you're just going to have rights over that trademark in whatever city or area that you're using the trademark. In terms of choosing a brand name, there are different levels of protection for how strong your trademark is. So the strongest trademark is something that is called coined or fanciful. So this is a completely made up word. You made, like Kodak or Starbucks or Reebok are good examples. Those aren't real words, those are made up. So those are strong brand names. Arbitrary would be like Apple for computers, right? Apple's a real word, but computer doesn't sell apples. So that's also going to be a strong brand name. Then you go into some weaker type of brand names. Suggestive would be you're not describing exactly what your good is, but you are kind of suggesting what you sell. For example, copper tone, you know, that's not a suntan lotion, but you're going to get a tone that's somewhat copper in appearance. So you're kind of describing it. You're just connecting your brand name to the product a little more. Harder to register trademarks would be descriptive trademarks. If you're looking at yellow pages, for example, you're really kind of describing what the phone book looks like. It's pages that are yellow. You know, you're not calling it phone book, but you're getting closer to that. If you're looking at picking a brand name, you can also always use your last name or your first name, but that's going to be harder to protect in a registration because other people have the right to use their name in their businesses as well. But there are exceptions where you have a name like McDonald's that started off as someone's last name, but of course that's a very strong trademark today, and that is also a registered trademark. What is not going to be registerable as a trademark is something that's very generic. For example, if you just took Apple to sell apples, you know, anyone's allowed to describe the good that they're selling, so you're not going to be able to get a trademark over a name like that. In terms of filing for trademarks, it's pretty easy. You can do this online through the USPTO. You just want to get your filing done as soon as possible. The first to actually start using a trademark, that's when you start establishing your rights. So it's important once you have your business brand or your business name to start using it immediately. You'll be able to block people that come after you to try and use your same trademark name. When you file for a trademark, you have to describe the goods, and then you'll get your trademark filing for certain classes. So example, if you're Apple, then you're going to get computer related classes. If you're selling t-shirts, you'll get classes for your brand name and you know, like a clothing category. And then you'll also submit a specimen, meaning you have to show the USPTO how you're actually using your name in connection with the goods you're selling. Or for services, you know, you have to prove that you're using your brand name in connection. Like if you're selling software, you have to, you know, show something on a website where you're selling the software and describing what that software is to get your trademark. You also have to think about filing your trademark in more than just the United States if you're going to be selling goods or services outside of the United States. And that's when you'd want to get an international attorney involved to try and navigate where you should be filing those trademarks. You definitely want a registered trademark, like a federally registered one. This gives you more legal protection. It's presumed that you own that trademark. You know, you have the exclusive right to use it. You have a better chance in filing lawsuits and protecting your brand. You also have a better chance of collecting damages. And so for use of symbols, you can use the little TM symbol on trademarks that are not registered yet. So if you haven't filed or don't plan on filing for a federal trademark, then you would just use that. But you would want to use the R with the circle once you have a registered trademark federally, but you are not supposed to be using that if you don't have a federal trademark. Avoiding being in trademark litigation is also important if you're starting up a company. Do your due diligence. It's pretty easy. Google search, you know, Google search is the best for almost anything in life. So I definitely recommend doing that. Just search for a brand name that you're looking at using and see if anything pops up. You can also search, if you type in TESS, T-E-S-S online, you can pull up the USPTO registered trademarks and do some searches in there. Super easy to use. Just make sure no one else is already using the brand name that you want to use. Definitely watch out for you know, any other big brands. Fashion brands are very litigious, and So you want to avoid overlapping with them because they're trying to protect their product and make sure people are buying, you know, $1,000 purse from Gucci or Prada or something like that. Also, when you're picking your brand name or a logo or something, don't send out emails within your company saying, hey, look, I found these other brands. You know, I like the way that some of our competitors look. You know, can you make something similar to this? You definitely don't want anything like that in writing, or don't want to do that, because that's just going to set you up for potential lawsuit in the future. I'm going to move through some of these other points just because we're running low on time. So if you do get sued for trademark infringement, you're looking if consumers are confused at where the good that you're selling is coming from. So there's a lot of different factors that go into that, but basically you want to make sure that where your goods are coming from and your brand name are not to be confused with others. And that's really the meat of what is focused on in any trademark litigation. So then the last area of IP is trade secret, and this is confidential information that has commercial value. This is really the alternative to filing for a patent. You might not want to disclose your confidential information or your invention publicly. Like, that's the whole point of patents, is that you're going to disclose you know, what your invention is. So you might want to just decide to keep it secret and establish these trade secret rights. And you get your trade secret instead of 20 years for patents. With trade secrets, you are protecting that information as long as you keep it secret. But that is also the gamble, is that once your trade secret is disclosed, whether it's an accident, whether an employee takes that information and discloses it, then you're not going to have trade secret protection anymore. You know, so it's over. So that's really the risk you take with trying to keep a trade secret. Also, it's legal to reverse engineer someone's trade secret. So you can buy someone's product, take it apart, see how it's made, and then recreate that yourself. That is also that's going to be a legal way for a competitor to steal your trade secret, and then you no longer have protection. In that case, you would want the patent, so that if they do that and start copying your invention, then you would be able to go after them for patent infringement. There's lots of different things that can be trade secret: supplier list, customer list, pricing info, product formulas. You know, there's a lot of stuff that you want to protect and keep a secret within your business. Here are some of the more legal terms for this, what a trade secret is. What you want to do to maintain secrecy, this is an important part, is to keep the trade secret information protected. You know, sometimes if it's like a physical recipe or something, you keep it in a safe and guarded. But normally in a business, this would be encrypting information, keeping it password protected, having good network security, only letting employees who really need that information have access to it, split up which different employees have what information, and finally just labeling stuff as confidential so people know that it's confidential. We talked somewhat about losing the secrecy. You're going to lose it if employees disclose it to the public. If you're going out to other people as a business owner and disclosing information, you lose that secrecy. And then the reverse engineering stuff I mentioned. Non-disclosure agreements, very important to have these if you're starting up a company. You want it to be an actual agreement and not just a handbook. Like, you want them to, a new employee to be signing these type of agreements, promising to protect confidential information. You want to define that confidential information so that they know what is to be confidential. You don't want to define that so that literally any piece of paper within your company is confidential, because later down the line, someone can attack that and say, well, how did your employee know it was confidential? You didn't describe it for them enough. You said anything was confidential, and then that agreement can be voided. So you definitely want to watch out for that. So the goal, keeping an enforceable non-disclosure agreement. Some famous trade secrets, Coca-Cola, WD-40, KFC recipe, the Google search algorithm. These are all famous examples of stuff that has not been patented, but instead kept as trade secrets. I've already discussed the differences between trade secrets and patents, but there's a slide on that. And then avoiding trade secret misappropriation. If you're leaving a company, the last day you're at a company, don't take your entire file and copy it and then go to a competitor. I mean, that's just setting yourself up for litigation. You want to make sure that you're not taking anything from your previous employer. You don't want to go to your new employer and bring them your old documents, because then you're going to end up getting them in trouble, start big fights. You definitely don't want to ask people at other companies to give you their information. You basically, any of that stuff is going to be improper, and you don't want to do that. You don't want to be involved with a bunch of legal fights, because that is definitely not an enjoyable thing to be a part of. We're definitely running out of time. I think that covers everything.
There are a couple questions. Do you want to take those, Clark, before we wrap up?
Sure. I'm popping out of the screen so I can look at the Q&A right now.
I can read them for you.
Okay.
So there's a question from Tom. Applied for a trademark that had previously been used and was abandoned. The reply from USPTO was that the use of this particular trademark was now not allowed as it was too obvious. Is there a way to appeal?
Yeah, so the fact that there was a trademark that existed and got abandoned, that means that that trademark is open. It's no longer being used. You can go and get that. I don't know if the application is still open or not, but you can definitely, just because the trademark office says we're not going to give you this right now, you can always respond to that and argue that you should be able to get that trademark. They might have, I don't know exactly what they said, but they might have said the mark was too descriptive or had some reason, but you can always fight back. You're really negotiating with the trademark office to convince them that you should have a trademark, and use examples of how much you've been using your brand, how other consumers recognize that your brand and associate it with their goods. So you can always argue back and try and get that trademark.
All right, next question from Aditya. You mentioned "I don't know" as a defense. Are there cases where this defense works or reduces penalties in patent or trademark?
And sorry I have more time to talk about that point on one of the slides, but yeah, you can't, it definitely, the defense can help reduce your damages, but the whole point of a patent registration or a trademark registration is you're putting the general public on notice that it's called constructive notice that your rights are out there. And so just saying, I don't know, that doesn't excuse you. You're required to do your due diligence and search for other patents and search for other trademarks.
All right, next question. Suppose I have a personal invention that I would like to pursue. A lot of companies have NDA that say any invention that I author would be part of the company. Is this legal? Is there such a thing as inventor's rights?
So I would say generally there's always inventor rights at the beginning, and then you have companies that are obviously trying to say that anything that you're inventing while at the company belongs to them. What you want to do is separate out anything that you're inventing on your own time and have that completely separate from your company. So you don't want to be working on any inventions using your company's resources, your company's computers, their files, any information you're getting from the company. You want to try and do a disclosure to them before you start working at the company that you've already started on an invention and that you know, you claim that it's yours. I'm not sure exactly what you know, some of these NDAs say, but there's usually room to carve out what you've vetted before, saying that you're already, you know, working on an invention on the side, and try and scope that out from your employment agreement.
Awesome. Thank you, Tarek. I think that's all of our questions.